Okay, thank you for all of the argument. I appreciate it. As you've seen, I've been taking copious amounts of notes and paying attention. Mr. Guinan, is there any reason why the court should not proceed to sentencing at this time?
No, Your Honor.
Ms. Chalupka? Thank you. The court has reviewed the pre-sentence investigation report and the recommendations provided in that report. I've also considered all of the sentencing factors set out in Nebraska Revised Statute Section 29-2260. One of the character letters provided as part of the PSI said that Mr. Wasson's mistakes do not erase the contributions he made to the Scottsbluff and Geary communities, and that person is right. Everyone who wrote me a letter, regardless of the sentence they wanted to see, said that Mr. Wasson is a stand-up guy who regularly goes above and beyond to help neighbors, friends, children, and strangers. Mr. Wasson's accomplishments, however, do not erase his mistakes. The court has carefully considered the full picture in this matter, including Mr. Wasson's outstanding character as well as his outstanding mistakes. Having regard for the nature and the circumstances of the crime, the history, character, and condition of the defendant, the court does find that imprisonment of the defendant is necessary because a lesser sentence would appreciate the seriousness of the defendant's crime and promote disrespect of the law. I find that there are substantial and compelling reasons for a period of incarceration, which include the fact that the defendant was not just a police officer in Scottsbluff, but he was a captain in the force. He was just below the chief and in a position of power and authority over his fellow officers. That Mr. Wasson interfered with at least 3 active cases due to his actions. That Mr. Wasson took evidence from other cases and provided it to his dealer, potentially putting the drugs back out on the street. And then the sheer amount of drugs and cash that were taken, which doesn't include approximately 15 to 20 years of stolen drugs from the drug take-back program, which was not calculated. I will let you know, when considering my sentence, I started out, I essentially attributed 1 day for every unit of drugs that was stolen. Calculating that would have resulted in a period of incarceration of 68 months. However, in considering this incarceration, I did know some of the mitigating factors that have impacted my decision. First off, including the LSCMI report or score, which indicates just a moderately increased risk to reoffend. The fact that Mr. Wasson has no criminal history prior to this offense. As Ms. Chalupka said, all of his actions are completely attributable to an addiction that was known, that was involuntarily foisted upon Mr. Wasson. The fact that the addiction did stem from the injuries sustained in the line of duty, and that Mr. Wasson has been honest and very cooperative in the investigation process and admitted to his wrongdoings unprompted. I also will note that in considering the maximum amount of sentence, I have considered adding time for the cases, the active cases that were affected by Mr. Wasson's actions, and thereby tampering with the prosecution of those cases. So in conclusion, I will say that I'm going to sentence the defendant to a period of 40 months, a minimum of 40 months of incarceration, a maximum of 68 months of incarceration. The jail sentence imposed herein is to run concurrent on both counts. I am going to adopt the agreement regarding restitution and sentence the defendant to pay restitution in the amount of $7,000 even. Would that be payable to the Scottsbluff Police Department? I'm not exactly sure how to do that since it was evidence technically not belonging to the department.
Right, Your Honor. I think the balance left would be this, was it $1,720?
Yeah.
And it would be paid back, because I believe it was evidence in some form or format, so it would be given back to the Scottsbluff Police Department.
Thank you. So I'm going to order the defendant to pay restitution in the total amount of $7,000. I understand there is a check in the amount of $5,280 that is either in the possession of the State Patrol or the Scottsbluff Police Department. That would make the remaining balance due $1,720. I'm going to note the total amount in my order because that is the total amount restitution that I'm ordering, and then I believe that there can be cooperation to reflect the $5,280 that has already been paid. The defendant will be responsible for the costs in this matter. The defendant's bond, if any, is released, and any amount not subject to a lien may be applied to the payment of court costs and fines that have been imposed in this matter. Am I missing anything, Mr. Guinan?
Not from the state, thank you.
Ms. Chalupka? Okay. So for the purposes of the record, this is a final appealable order. Mr. Wasson, I am going to remain in custody of the Scottsbluff County Sheriff's Department. Thank you everyone for coming today. Again, I really appreciate the arguments and the perspectives from everyone. I know this is a rough case that has affected countless people that aren't even here in the room, and I appreciate all of the information. Thank you. We are adjourned.